The Federal High Court in Abuja has struck out 8 of the 15-count charge against the leader of the Indigenous People of Biafra, Nnamdi Kanu. It can be recalled that the federal government had filed a 15-count charge bordering on terrorism against Mr. Kanu. As the case resumed on Friday, April 8, 2022, the presiding judge, Justice Binta Nyako, struck out 8 of the charges while delivering a ruling on the validity of the charges. Justice Nyako held that in the instant preliminary objection application, counts 6, 7, 8, 9, 10, 11, 12, and 14 have not disclosed any offense by the defendant. She, however, acknowledged that counts 1, 2, 3, 4, 5, 13, and 15 showed some allegations against the IPOB leader, saying the trial of the defendant would proceed on those counts. On the issue of the proscription of IPOB, the judge held that the case was pending before the appeal court, and as such, the order proscribing the organization was subsisting until it was vacated. The lead counsel to Kanu, Mike Ozekome, however, described the charges as defective and baseless. Mr. Ozekome said his application seeks the quashing, striking out, and dismissing of the 15-count amended charge for being incompetent and denying the court of jurisdiction to entertain the suit. The application, premised on 34 grounds and supported by a 36-paragraph affidavit, is also seeking an order acquitting and discharging Mr. Kanu. Mr. Ozekome asked, "You are accusing Kanu of making some broadcasts. You didn't say where these broadcasts were made. Were they made in the spirit world, made in the air, or under the ground?" He also said, according to the provisions of the Federal High Court Act, a prosecutor is expected to give exact details of a location where an offense is committed. Mr. Ozekome adopted his application and asked the court to strike out the entire charge. The federal government lawyer, Labaran Shuaibu, however, asked the court to dismiss the defendant's application. Mr. Shuaibu, speaking to newsmen after the court hearing, said,
"And the court, in its wisdom, now reviewed all the charges and discovered that with the exception of 7 counts, about 8 counts appear to be similar, and those charges were struck out."
Here is what Mr. Shuaibu has to say on the proscription of IPOB.
With respect to membership of IPOB, which he denied, it was the argument of the defendant that the matter is on appeal, and whether IPOB should be a proscribed organization under the Nigerian law or not. The court also emphatically said even though the issue is on appeal, but what is the case is that IPOB still remains a terrorist organization within the confines of Nigerian law.
Then there is the matter of Mr. Kanu flouting all the conditions of his previous bail.
He moved another application for bail again, which the court ordered that both applications be taken and arguments were proffered. And it was also in their argument that Nnamdi Kanu had never flouted any of the conditions of the bail. And we have argued vehemently, showing to the world, showing to the court that he has actually flouted all the bail conditions. And that was the reason why the court has ordered for his revoked bail and ordered for his arrest.
Proceedings here on Friday was without the presence of the media. It will be recalled that a new directive was issued 48 hours earlier by the Chief Judge of the Federal High Court, Justice Sow, barring the media from covering Mr. Kanu's case and other terrorism cases. Reacting to this new directive, the lead counsel to Nnamdi Kanu, Mike Ozekome, said,
"But there are areas in the new practice directions, but I'm worried about one provision that screens off journalists, the media, the fourth estate of the realm under section 22 of the Constitution. Because if you stifle information, the wrong information can emanate from the rumor mill, and that is a more dangerous issue. The Supreme Court said so, and I think that was in the case of Adesanya, the President of the Senate. if you stifle information, then the rumor mill will become very active. You don't hide information. So when you prevent the media from covering a trial, then it may lead to generation within the rumor mill of things that never happened, which again jeopardizes the fair trial of an accused person, even of the prosecutor and even of the judiciary itself. But I'm against the issue of making it look like a secret trial, as if a trial is like a gathering of witches and wizards in a coven. It should be a public trial which the whole world can watch. Then when you come here, you can screen out the people and decide on how many people can attend, the same way that we have been doing it. I believe that because of that, by the grace of God, I'm going to challenge some portions of the new practice directions as being unconstitutional and against so many sections of the Constitution of Nigeria.
The case was, however, adjourned to the 18th and 26th of May 2022.